Good afternoon, everybody, and welcome to the session today. It's my pleasure to introduce Ian Rennie and Matthew Yap, who will be speaking to us about affidavits and other interesting things. A couple of quick reminders. If you could keep your mics muted, that would be great. That'll avoid any background noise. If you've got questions, pass them on to me, and then I'll pass them on to the presenters. And finally, we are recording this session and we'll be putting it up on the Law Society's YouTube channel shortly after the session is completed. So with that, I turn it over to Matthew and Ian. Over to you, folks.
Thinking that your technical
That's me.
issues. Go ahead.
Good afternoon, everyone. Matthew here. Sorry, apologies for the technical difficulties here. We've just been very ably assisted with Bob and Glenn, and we're here now. We're able to start. I hope everyone can now hear us. If you can't, please let us know, and Glenn can. No.
We're unmuted.
We're unmuted.
Okay, good.
Good afternoon. My name is Ian Rennie, and beside me is Matthew Yap, and we are doing a CPD presentation on the Notary Public Program in the Northwest Territories. We would like to acknowledge we are on the traditional territory of the Yellowknives, Dene, on the Chief Dry Geese territory as part of Treaty 8 in Yellowknife Northwest Territories. We also acknowledge that this land is also the traditional territory of the Clicho and the North Slave Métis Alliance.
How it works, about it, ways about going about getting appointed, how the appointment process works, and then talking about the staff law, the rules that apply, and some of the ethical considerations for lawyers and notaries public, and finally giving some practice tips and some common errors that we see that notaries do in order to help try and avoid those in future. The agenda for today's CPD is here on the screen. We're going to talk about affidavits and statutory declarations and what the Notary Public is, some of the foundations, the program. Then I'll turn it over to Ian to discuss the authentication process and the apostilles. We'll go into some of the legal duties, the code of conduct, Notary Public handbook that we have, the errors, some rules, examples, and then questions. And if there are any questions throughout, as Ben mentioned, please don't hesitate to put them in the chat, and he will raise them with us. And the next slide.
And this is a list of references organized in alphabetical order. There are other references in the presentation if you want to follow up on it. We've included the hyperlinks, including their URL paths. You can see that there's a fair number of statutes, ATIPA, the Canada Evidence Act. There's also the Territorial Evidence Act, Code of Conduct of Northwest Territories. There's some mention of the Criminal Code, the Hague Convention, also called the Apostille Convention. There's a handbook called Information and Instructions for Notaries Public that's published by the GNWT. There is a Law Society bulletin about freemen on the land, which we will discuss shortly. Legal Profession Act, of course. Meads versus Meads, a very interesting divorce case where the presiding judge, goes into an academic analysis of freemen on the land. Crown versus Wooey, everybody's favorite law school case, the Chicken Bones case. And then, of course, the rules of the Supreme Court of Northwest Territories, Part 30.
Okay, so in the posting on the Law Society for the CPD, somehow in there it got a word saying it'd be entertaining. So we were looking for a joke, but then we realized that we were not that great on our jokes as in the registries. But we did find a cartoon. So here's our entertainment for the CPD. It's interesting and topical to this topic, and it goes very much to the fact that as notaries, one of the things that we have to satisfy ourselves with is to ensure that any declaration or affidavit or the person that's coming before us has the capacity, and whatever they're doing is voluntary. So a little cartoon about notaries. So for the introduction, this is a topic that is very much a bread and butter activity for lawyers and people who are appointed as notaries public in the Northwest Territories. But despite being something that's very common amongst all the lawyers and people who are appointed as notaries public, it's not necessarily something that's taught in law school or learned in an academic setting. Rather, I can speak from my own perspective, is that I learned this from my principal when I was articling, and pretty much how the practice happened in my office, and it kind of developed that way. And it's something that lawyers are called upon to deal with all the time, and sometimes it might be helpful to have this understanding of what the processes are and why they are. So this presentation, of course, is aimed at lawyers, as this is a CPD with the Law Society, but it's also anyone who's appointed as Territories Notary Public, because it's relevant to them as well. So to start off, what are we dealing with? The first thing is we're often talking about affidavits. So a reminder of what is an affidavit. An affidavit is a written statement made on oath or affirmation about the facts that are personally known to the person making the affidavit or the deponent. And as these things indicate, there are several key parts that are required in order for there to be a valid affidavit. So it has to be something that is personally known to the person making the affidavit. We don't allow someone to say, well, I believe someone told me, someone told me, someone told me, hearsay, unless it's actually under, and specifies that's under their knowledge or belief. And because an affidavit is sworn to be true, or is affirmed to be true, it can be used as evidence of the facts that set out in the affidavit, just as the facts were given verbally at a trial while a witness in the court. And of course, they are legal documents and are treated as such. There are several elements to the affidavit. So there's a style of cause, there's a title, the statement of the identity of the affiant or deponent, and through the preparation for this CPD, we notice that in the rules of court, I believe it still says that we're supposed to be identifying the occupation of the affiant. That there should be a statement of truth as to the truth of what's contained in the affidavit, the statement of the facts, a reiteration of the statement of truth, and then finally the jurat, which also involves the signature of the affiant and deponent, and the notarization by the Notary Public or the Commissioner of Oaths. And if there are any exhibits that are attached to the affidavit, those are also identified in the affidavit, and each are labeled to that effect, and each of the exhibits are also notarized. Quick example, we pulled a example affidavit from the rules of court. This is Form 51, and it pretty much outlines how you can see there is a style of cause. It identifies itself as an affidavit, it identifies who the person is, and various facts and statements that are being sworn. And then at the bottom, at the right-hand side, you can see that sworn before a blank area, which will be for the Notary Public. Something we often see is making sure that we understand where the notary should be signing and where the affiant should be signing. And in this case, the affiant will be signing on the right. And if this was an exhibit, Ian has imposed an example of a stamp that would identify any exhibits.
Notice that the occupation is not specified in the identification portion. That's an interesting observation.
So similarly, there's also statutory declarations, which are related. So these are documents that even, they're sworn by a person making statements with a solemn declaration that it's true. And these are made pursuant to the Evidence Act or the Canada Evidence Act, as the case may be. And these are usually for situations which where there is a statement that's required, but it's not exactly specified, not necessarily where there's actually a court action that's been commenced. And similarly to the affidavit, there's several similar aspects to it, although there is no style of cause, or there would be a statutory reference and various things that talk about the identity of the person, the facts and evidence that are contained in the declaration, and the same jurat process where there's a signature, there's a notary public or commissioner of oaths, and any exhibits that are attached to the declaration. And then here is an example of a statutory declaration. In this case, we pulled the change of name regulations. And in this case, the GNWT has already provided a set form for these declarations. And at the bottom right of the document, which is highlighted in the blue brackets, we have where the jurat would be. So what is a notary public? So a bit of historical aspect here. So notary publics hold an important public office, which is critical for the administration and legal system because there's often times where people have to swear or affirm various documents that are used for changing their name or registering documents and land titles or identifying that they lost a document and need to have a replacement. These are quite routine matters in government, and a notary public is critical to ensure that the administration of the legal system can continue to function with the various formalities. The office of a notary public can definitely trace its origins back to the Roman period, and then it was adopted through the church and the medieval period and inherited from Canada through the British and French. A notary public is considered a law officer with the public office, and they have a duty to certify, under their seal, any documents as proof of the matters contained within them for legal and public purposes. I'm now starting to get into a differentiating between notary public and commissioners of oaths. These are often sometimes confused. The main issue and takeaway is a notary public has all the powers of the commissioner's oaths, so they can take oaths, affidavits, affirmations, such. But they also have the added power to be able to notarize documents, which then can also be used outside of the Northwest Territories. Certain powers that the commissioner of oaths doesn't have, and which we'll get into in a little bit. A question that's often asked is if a notary public can charge a fee for their services, which is yes, they can, and that's pretty much whatever the notary public and their client may agree upon for those services to be provided. Here is a quick chart which identifies the differences between the two appointments. So on the left, we have the powers of commissioners of oaths, and then on the right, notary publics. A lot of them are very similar up until the point at the very end where commissioner of oaths cannot certify true copies of documents. They only take the oaths. So commissioner of oaths cannot say, I certify these to be true copies. That's power and duty for a notary public. And then powers can be used inside and outside the Northwest Territories for a notary public, whereas for commissioner of oaths, they are restricted to within this jurisdiction.
I am just having a look at the statutory foundations of notary public. And this brings us to Section 79 of the Evidence Act. So I know this is hard to read, but I'll just go through it briefly. Subsection 1 sets out the requirements for the appointment. So the minister may, in the discretion of the minister, by one or more commissions, appoint notaries public for the Northwest Territories, but no person may be appointed as notary public unless. So they have to be a permanent resident of Canada, reside in the territories, entitled to practice as a barrister or solicitor in the territories, or satisfy the minister in the case of non-lawyers, pursuant to an examination that the minister may impose that he or she is qualified to act as a notary public. So there is an examination process set out in the statute. The minister is satisfied that the appointment of a notary public is necessary for the public convenience in a place where the person to be appointed resides and intends to act as a notary public, and where the person to be appointed is an officer, servant, or employee of the Government of Canada in the places where the duties of that person require him or her to be from time to time. In terms of an entertaining portion, the public convenience, I looked at that word and another meaning sort of came to mind. Subsection 2, where a person other than a barrister and solicitor is appointed or reappointed as a notary public, special restrictions may be imposed on the commission, limiting the area, duration, or purpose for which the persons may use and exercise his or her powers. So it is possible in the instrument of appointment to actually restrict the powers in some way for persons other than barristers and solicitors who are appointed as notaries.
Okay, so a little bit about the administrative aspects of the Notary Public Program in the Northwest Territories. So Legal Registries of the Department of Justice is the ones who administer the Notary Public Program here. We provide a handbook for notaries public. We do note that if there's any inconsistency between the handbook or any legislation, the legislation, of course, takes priority. And there's a link there in order to, if you would like to consult the handbook. It's available on the website at that link there. How does one become a notary public? So in this jurisdiction, there is a requirement that an application form be completed and submitted to legal registries. As Ian mentioned, an exam is administered for applicants other than lawyers, and the minister may go and appoint the applicants who satisfy the various requirements. Interesting, Section 65 of the Evidence Act talks about how in certain positions, ex officio, like a judge or a clerk or commissioned officers, have the powers of commissioners' oaths, but it's important to recognize that these are not the powers of notary public, and they're not notary publics by virtue of their office. So a quick summary chart of the appointment requirements, and this will be available, the PowerPoint will be available for participants later if you would like to consult it. But the common ones are at the top. So Ian mentioned you have to apply, you have to be Canadian or a permanent resident. You have to reside in the Northwest Territories, and that also goes for lawyers. So if you are a lawyer who might be an active member of the bar, but are currently residing in British Columbia, it's not satisfying those requirements. Identification of the minister that is necessary for the public convenience, and pay the fee. So the additional thing I want to mention is on the left, lawyers are not appointed automatically by virtue of their admission to the Law Society. They also need to apply to legal registries, and they must be in good standing in order to be entitled to practice. So we interpret that to being an active member. And on the right is the requirements for those who are not a lawyer is to pass the bar exam.
And just to reiterate on that red point, the appointments are not automatic. Lawyers must apply in this jurisdiction. I'm also a member of the bar in British Columbia, and when you're admitted to the Law Society in British Columbia, you are also an ex officio notary public. But that is not the case here. One has to still be appointed as a notary public by the minister. So I can actually notarize documents in this jurisdiction, but they can only be used in British Columbia.
Okay, so big highlight for a lot of lawyers, and I think it comes some news to some because we often get some of these questions, but of course do apply if you have not done so. And of course, as Ian just mentioned, contrast with BC. A little bit more administrative details about the Notary Public Program. So the GNWP does collect information in the application forms in order to identify who the people are who have been appointed. These names and appointments are published in the Northwest Territories Gazette every month. We provide database where we have the specimen signatures and specimen seals and the contact information of the Notaries Public. All this information is not publicly accessible, but we keep that in order to satisfy the registry of who are the Notaries Publics in this jurisdiction, and when it comes to dealing with authentications, which we'll deal with later on in the slide deck. If for whatever reason your contact information has changed since the time you applied to become a Notary Public, we would ask that you please contact Legal Registries to update your information, and any of those updates are free of charge. Same with your seal. If it's changed, it's critical that you provide the updated specimen to Legal Registries as soon as possible. In the event that a document requires to be verified, and again, that is free of charge.
Matthew, we have a question. The question is, can a notary public who normally resides in the NWT notarize a document outside of the NWT? For example, if they were traveling in Alberta, could they notarize a document there? Can either of you comment on that?
Well, I can only use my example. If I were to notarize a document in the Northwest Territories for use in British Columbia, I would have to use my seal from British Columbia. So I'd be exercising my powers as a notary in British Columbia. If I were in British Columbia and notarizing a document there for use in the Northwest Territories, unless there's something contrary to that in the Evidence Act, I think it would be okay. But if I'm in Alberta and I decided to notarize a document for use in Ontario, I think there might be a problem there because I'm not a member in either of those jurisdictions. And if I were in Alberta and I notarized a document for British Columbia, I think that's fine as long as it's only for use in British Columbia. But I would have to do it under my British Columbia seal.
I spoke about the internal directory. There's also a public directory of Notary Public that the Department of Justice maintains. So, as I mentioned, there is the publication of appointments in the Gazette, which includes the Notary Public's full name, the community, and the date of appointment. And we also have a portion of our website which provides a directory. And this is totally voluntary if you wish to be included into it. And the reason why we have it is because the Department of Justice regularly receives inquiries from members of the public who are trying to find a Notary Public in order to do whatever the document is that they need to get sworn for or authenticated or complete their affidavit. And in response, we at Legal Registries provide the list of Notaries Public who have identified to us that they are willing to provide these services to the public and are happy to take any of these referrals. This list is communicated to the public and it's published on our website. If you would like to be added or to be removed from this list, please contact our office and we'll be happy to make those changes for you. And we would definitely encourage members of the bar to consider putting their names on that list and being able to provide the access to justice and the services to the members of the public. Here is a screenshot of the current list on our website. So if you go to the Legal Registries website, on one of the pages, you'll see this list, and these are the list of people who have currently identified that they are willing to take referrals of people who are looking for Notary Public. And so if someone calls us at Legal Registries, we'll say, here's a list of people that are happy to do the document for you. You'll notice here the presence of several corporate bodies. It's important to know that bodies corporate are not Notaries Public, but rather individuals within that firm are the persons that are doing the services for the public.
So authentication and the Apostille Convention. A Notary Public may be called upon to establish that the oath or affirmation in a document was properly administered. We call this authentication. Authentication avoids a Notary Public being called for cross-examination in a court. There is some problems that arise where a notary public has died or is no longer available. For example, they've moved out of the jurisdiction with no contact address. Legal Registries receives requests from high commissions, embassies, and consulates to authenticate documents executed with a notary public. These requests assure foreign governments, or at least the authentication assures foreign governments or parties that the document was duly executed under the Canadian legal system. That's why the specimen signature, seal, and contact information are collected by Legal Registries and put into their database. In response to authentication request, GNWT verifies that the notary public was appointed at the time of the document's execution and that the signature and seal match the database. If authentication of the document can occur and of the notary's signature, then Legal Registries provides a letter to that effect to the foreign entity making the request. If a notary public was not appointed or registered, or there's something wrong with the specimen signature or seal, then Legal Registries reports that the document was not properly notarized or that it cannot confirm the authenticity of the document. Such an outcome may have dire consequences if the notary public did not take the required steps to maintain their information with the Department of Justice. If a person is acting unlawfully as a notary public without having been appointed, enforcement action could be taken. I guess that would be done by GNWT. The Apostille Convention, more formally known as the Hague Convention, abolishing the requirement of legalization for foreign public documents, is an international treaty drafted by the Hague Conference on Private International Law. So you can look it up on the internet, it's there. It specifies that modalities, or the modalities through which a document issued in one of the signatory countries can be certified for legal purposes in all the other signatory countries. Certification under the terms of the convention is called an apostille, from Latin and also French. It's really a French word, apostille, meaning marginal note. An apostille is an international certification comparable to a notarization in domestic law and normally supplements a local authentication of a document. If the convention applies between two countries, such an apostille is sufficient to certify a document's validity and removes the need for double certification by the originating country and then by the receiving country. So there's a link to the treaty. Canada has not ratified or acceded to the convention, but it is considering potentially joining. Joining the Apostille Convention would involve providing information about notaries public to Global Affairs Canada under the authority of Section 48 of ATIPA in order to create a database for consular staff to check notary appointments from Canadian jurisdictions, a single centralized process to authenticate authentication requests, and authentications locally at any high commission or embassy or consulate. So it would facilitate all of these databases and things would help to facilitate being a state party of the Apostille Convention. Just a reminder of Section 48 of ATIPA, and in particular paragraph P. A public body may disclose personal information for the purpose of complying with a law of the Northwest Territories or Canada, or with a treaty, written agreement, or arrangement made under a law of the Northwest Territories or Canada. So when the treaty comes into force, it will have to be adopted by Parliament. And then we can rely on paragraph P. Many people look at ATIPA and they don't realize it. They usually look only at the first part and rely on access to information, but it's also the disclosure of information, authorized disclosure for public purposes under Part 2, and Section 48 comes under Part 2. The legal duties of a notary public. So this is taken from the Evidence Act. Section 83, every notary public shall have, use, and exercise the power of administering oaths attested by his or her signature and seal, attesting commercial instruments brought before the notary public for public protestation and giving of notarial certificates of his or her acts, and may demand, receive, and have all the rights, profits, and emoluments rightfully appertaining and belonging to the exercise of these powers. I'm sure everybody's knows the meaning of emoluments now, thanks to Mr. Trump. Section 84, the notary public has and may exercise the powers of a commissioner for oaths, and where the notary administers an oath or takes an affidavit or declaration within the Northwest Territories, it is not necessary to its validity that the notary affix his or her seal to it. So that's kind of interesting. 85, every oath or declaration shall be made in person by the deponent or declarant, in the case of a statutory declaration, in the presence of the notary public administering the oath or declaration, who shall satisfy himself or herself of the genuineness of the signature of the deponent or declarant, and shall administer the oath or declaration in a manner required by law before he or she signs the jurat or declaration.
So in addition, there's also some provisions that don't apply about offences related to affidavits. We have an extra one there on the right. It's very interesting to see that has been changes in this area across the country. So some jurisdictions have actually imposed lockdowns and curfews and stay-at-home orders and various other corresponding emergency rules, which talk also about the corresponding amendments to legislation about taking affidavits and video conferencing. Here in the Northwest Territories, we haven't seen the same level of lockdowns as some of the rest of the jurisdictions. And in the Northwest Territories, taking affidavits remotely is nothing new to us. It will be very interesting to see, in the near future, various case law or different interpretations of how, as a result of the pandemic, if something is being declared before someone using video, like Zoom or video conferencing technology. But in the Northwest Territories at this point in time, we would recommend, Notary Public continue to meet the affidavit or deponent in person, and use any personal protective equipment such as masks, or even doing the execution document through a window or through glass. But this is definitely something that we are monitoring and taking a look at, and seeing how the other jurisdictions are working out, and seeing how this sort of thing gets interpreted moving forward in the future. So interesting times in the world of substantive law for notary publics. We mentioned earlier that there are certain duties of a notary public. So in the requirements to be a notary public, there's certain aspects about having some level of professional competence and skill and knowledge of the notary public, in order to ensure that the public can rely upon a notary public who is knowledgeable about what their duties are, who knows about the process they need to follow in order to have a valid, jurat, how to take an oath and affirmation properly. There's a bit of case law that we've found from our fellow jurisdiction over in the Yukon with a Mr. Hanna, who is the cases there, and a link to it is also provided in the hyperlink. Very briefly, Hanna is a notary public. There's some concerns with his practice and conduct as a notary public by the Department of Justice in the Yukon. And based upon those concerns, his appointment was revoked by the minister, and that revocation was challenged in court by the notary public. Typically here in the Northwest Territories, revocation is a very extraordinary thing to do. Usually what we will do if there's any concerns with someone executing documents properly, we would usually have a word with them, or write them a letter, or invite them to refer to the handbook again. And it's also a case where we in Legal Registries, we don't have our eyes everywhere, and we would definitely be asking fellow members of the bar to say, if you notice a concern with someone's practice as a notary public, in order to steer them, to let them know that they have a handbook available, or they can always let us know. When it came to the court case for Mr. Hanna, we have an excerpt here of paragraph 8 from the decision, which the judge goes in quite extraordinary lengths. He says, the crowning point of incompetency with Mr. Hanna was an affidavit which was itself understandable, but he signs the affidavit as a deponent, so there he doesn't know where to sign the document properly. And then he affirms his own affidavit. And that alone was sufficient to revoke the person's appointment.
And when we did a Canley search for notaries public cases, this appeared to be the only case that we could find in the Canley, which is very interesting. And I think it's because in most jurisdictions in Canada, there is something like a societies of notaries public that self-regulates. So it's a self-regulating profession. And if you go to, for instance, the Societies of Notaries Public in British Columbia, they do have a hyperlink to their discipline cases, but there's nothing there. So a deponent, a notary public who acts as deponent and as the notary notarizing his own deposition or his own affidavit. What's wrong with taking an affidavit yourself, you as a notary and affiant or deponent? Consider 5.2 sub 1 of the Law Society Code of Conduct, and this is the ethical portion of this presentation. So here's 5.2-1. A lawyer who appears as advocate must not testify and submit his or her own affidavit evidence before the tribunal unless permitted to do so by law, the tribunal, the rules of court, or the rules of procedure of the tribunal, or unless the matter is purely formal and uncontroverted. If we look at the commentary, the lawyer should not express personal opinions or beliefs or assert as a fact anything that is properly subject to legal proof, cross-examination, or challenge. The lawyer should not, in effect, appear as an unsworn witness or put the lawyer's own credibility in issue. The lawyer who is a necessary witness should testify and entrust the conduct of the case to another lawyer. There are no restrictions on the advocate's right to cross-examine another lawyer. However, and the lawyer who does appear as a witness should not expect to receive special treatment because of professional status. So this is quite relevant to a lawyer who is also a notary public. But it's also the foundation as to where Hanna went wrong, because he was just a notary public. Question for you in that last slide: what effect does a breach of the code have? Go ahead. When acting as an advocate, a lawyer must not knowingly attempt to deceive a tribunal or influence the course of justice by offering false evidence, misstating facts or law, presenting or relying upon a false or deceptive affidavit, suppressing what ought to be disclosed, or otherwise assisting any fraud or crime or illegal conduct. Now, this is, if you remember the shark cartoon, as humorous as that was, there is a subtle, serious message there. If somebody comes to your office to have a document notarized, well, you are not proofreading their affidavit or statutory declaration. You do have to keep in the back of your mind whether or not it's going to facilitate some sort of illegal conduct and put you in violation of paragraph E here. So coming back to the question of what effect does a breach of the code of conduct have, if one goes to the preface, the code sets out statements of principle followed by exemplary rules and commentaries which contextualize the principles enunciated. The principles are important statements of the expected standards of ethical conduct for lawyers and inform the more specific guidance in the rules and commentaries. The code assists in defining ethical practice and in identifying what is questionable ethically. Some sections of the code are of more general application, and some sections, in addition to providing ethical guidance, may be read as aspirational. The code in its entirety should be considered a reliable and instructive guide for lawyers that establishes only the minimum standards of professional conduct expected of members of the profession. Some circumstances that raise ethical considerations may be sufficiently unique that the guidance in a rule or commentary may not answer the issue or provide the required direction. In such cases, lawyers should consult the Law Society, senior practitioners, or courts for guidance. Practice advisor comes to mind. The breach of the provisions of the code may or may not be sanctionable. So there's the answer to that question I posed. The decision to address a lawyer's conduct through disciplinary action based on a breach of the code will be made on a case-by-case basis after an assessment of all relevant information. The rules and commentaries are intended to encapsulate the ethical standard for the practice of law in Canada. Failure to meet this standard may result in a finding that the lawyer is engaged in conduct unbecoming or professional misconduct. And of course, that brings us into Section 22 of the Legal Profession Act. And you will note that the wording in the Legal Profession Act is slightly different than in the Code of Conduct. They talk about conduct unbecoming. Okay, that's the same. Or unprofessional conduct. I think unprofessional conduct and professional misconduct are probably the same thing. A good example of this sort of caution comes from Freemen on the Land, or the Sovereign Citizens Movement, what is technically called organized pseudo-legal commercial argument litigants. Individuals who believe that they are bound by statute laws only if they consented to those laws. They believe that they can declare themselves independent and that the only true law is their own interpretation of common law, not statutory laws. So this brings us to Meads and Meads, a divorce case of all things, but the judge provides a very full and interesting intellectual discourse about freemen on the land. And you can see that paragraph 1 of the case, these persons employ a collection of techniques and arguments to disrupt court operations and to attempt to frustrate the legal rights of governments, corporations, and individuals. In this case, it was an estranged spouse doing exactly that to another estranged spouse. Such persons use the services of notaries public to make declarations that they are not bound by law and believe that having these documents notarized will give them legal effect to absolve them from the rule of law. Notaries public have been disciplined for facilitating this. These are so-called paper attacks to obstruct and intimidate legal process, the administration of law, and parties. And it's still amazing to me that Meads is a family law case of all things. And here's a classic quote, and I won't go into it, but you can, well, maybe I will go into it. It's kind of interesting. How do lawyers and notaries fit into all of this? This is right out of the case of Meads. Freemen have attended law firm and notary offices seeking to have their documents, quote unquote, notarized. The documents have strange wording, stamps, blood, and finger seals, references to the Uniform Commercial Code, and biblical references and so forth. They are usually pseudo-legal and completely unlike any legal document that a lawyer or notary would draw or witness. In one case in British Columbia, the notary witnessed a series of documents with names such as notice of non-response, a notarial certificate of dishonor, and a notarial instrument of protest, which led to the creation of a true bill of notice of accounting for the sum of $3.5 billion. These were all stated to be against the BC Court of Appeal, which was not amused. In this case, the notary apparently witnessed the documents in her capacity as a notary acceptor. She was disciplined by the Society of Notaries Public for breach of Rule 11.01 of the notary rules and admitted that her conduct was contrary to the best interests of the public and the notarial profession. Lest one believe that only notaries have witnessed and notarized these documents, there have been instances of BC lawyers too who have been approached about acting in this capacity.
Okay, change gears a little bit. I mentioned earlier that we had the Notary Public Handbook at the Department of Justice, and I wanted to spend the remaining time with the CPD providing some information about the handbook and some of the tips that's contained within it. So this guide is available on our website, as was mentioned. It is updated from time to time, and some notable topics are as follows. So one thing that it talks about is a notary public, must, keyword must, impress their seal when it's required by law, or when the document is being used outside the Northwest Territories. Types of seals that you can get as notary public are as use wax, embossing, stamp, and the pencil method is talking about how we do it in embossing to help with the identification and viewing it. We would, however, ask that people not use wax seals. It's as I mentioned here, it's the year 2021, not 1021. And a little tidbit of trivia here is it's apparently a case that the term red tape comes from the long tapes of seals that used to be sealed onto legal documents back in the medieval times. And of course, if it is helpful, please consider using the red or gold legal seals. These are the stickers you can get at Staples or Creative Basics when embossing, because they can assist with looking at the seal and what the name of the person is on it, and helping with any scanning or photocopying of the documents that occur later. How to acquire a seal in Yellowknife. So as I mentioned, there's Staples or Creative Basics. You can also mail it from an order. And this is an example of how you may want your seal to appear. While there is no specified mandatory format of it, this is a typical example that we usually see here in the Northwest Territories, and of course identifies three key aspects. It's the name, the jurisdiction, and they are a notary public.
Please don't indicate when you in order that your name is your name here.
Yes. And then here we have some examples from Ian's seals. So he provides the red sticker there, and you can see the difference between the embossing on the seal sticker and not. One is more visible than the other. On the bottom right, you can see the pencil method of helping make sure it tries to be more visible. Not as effective, but better than nothing. With the left as well. And it's giving an example of how to smudge it.
And at the top, there's also the stamp. So it says my name, and then it says, what does it say? Read it. It says a notary public in and for the Northwest Territories. My commission does not expire by being a barristered solicitor. But that's not the same thing as saying that you have a commission as a notary public by virtue of being a barristered solicitor. I actually do have an appointment from the minister from 2012 and as a notary public for the Northwest Territories.
So another aspect of the handbook is certifying true documents. And then often come up with us, and we have here an example of the text that can be used. It's available in the handbook, and it pretty much identifies how you certify that that's a true copy. There's an area for the notaries to identify who it is and their signature, their jurisdictional authority. And if it is not a lawyer, their appointment will be expiring at some point in time, and to identify when that expiry occurs. But the key aspect here, which we often find there's sometimes an error occurs, is that the notary public must actually see the original document and the copy before certifying the copy as being true. So the notary public has to actually have and see that it's an authentic original document, like see the original ink signature if that's applicable, and be satisfied that it is the original. What they cannot do is the notary public cannot notarize a true copy of a copy of a copy and any copy of the original document. The key aspect is they have to see the original in order to say this is a certified true copy of the original. So a couple of unique situations can occur with your client particular circumstances. So the first one that's talked about in the handbook, there's more detail about it in the handbook if you want to consult it later. But if you are working with someone who is blind or illiterate, it's important to read the document to the client and amend the jurat accordingly to identify that your client was, blind or illiterate, and identifying how you read the document to them and they agreed with what the contents of it were. When working with someone who is hearing or speech impaired, we would encourage people to use a sign language interpreter and ensure that both the client and the interpreter can understand each other. And of course, amending the jurat accordingly to document how the process of the execution of the document or affidavit occurred. If you're dealing with someone who doesn't speak the same language as you, you should be using someone who is competent to interpret or translate in the language and ensure that they both understand each other and that they understand the contents of the document that they're signing. And then again, amending the jurat accordingly to document the translation occurred. When there is a question about the client's competence, mental capacity, or voluntariness, so these are issues where we want to make sure that what they're doing, because often the things that are being sworn to or signed have significant legal implications, say like you're buying or selling a house or dealing with their life savings. We want to, of course, always make sure that what the client is doing is what they actually intend to do, and they understand the nature and effect of the legal documents and the decision that they're making. This also goes to the cartoon earlier, how by meeting with the person, you are able to have some kind of gauge of that and making sure that no frauds or any duress is existing. And if there is any doubt as to the competence, capacity, or voluntariness of your client, you should take steps to satisfy yourself, or in further doubt, not proceed with what's occurring. And it might be difficult if that's what the client is wanting, but you do not want to be putting yourself in a difficult position where the document later comes into question and a year later call onto the stand to say, was this document actually, validly executed and is properly done?
And just a comment on there, the client may be actually quite competent and they may actually have very good mental capacity, but it is possible that the document that they are having notarized is serving some sort of ulterior purpose in their mind. And so they might actually be doing something that they don't quite understand. And I have encountered that, and I'm sure many other people have. And I've actually refused to notarize a document in that case. And I also suggested that the individual should get independent legal advice.
The next portion that's talked about in the handbook is amendments. If there are amendments that need to happen through the document, those should have a clear strikeout and the correction indicated, and they are initialed by the parties to the document and the notary public. If you do not want to do the amendment process, you may also wish to just reconsider totally re-executing a fresh document cleanly from the get-go. As Ian mentioned with the earlier ethical aspects, notaries public don't notarize their own documents, and a notary public should also not be facilitating any illegal conduct.
So this slide is an extract from, I think it's mostly Part 30 of the Supreme Court rules. And so the Supreme Court rules have the status of a regulation. They're made under the Judicature Act. It has lots of details about affidavits, particularly when they're used in the court. An affidavit shall be entitled in an action or proceeding, or intended action or proceeding, and shall be drawn up in the first person stating the deponent's full name, occupation, and place of residence. So there's that occupation issue that was mentioned. An affidavit shall be divided into paragraphs numbered consecutively, each paragraph being, as far as possible, confined to the distinct portion of the subject matter. A date, some or other number may be expressed in an affidavit in figures and not in words. where an affidavit is filed by a party who has not filed a pleading in the action or proceeding, the affidavit must set out the address for service of the party. 368, Rules 368, an affidavit shall be signed by the deponent and the jurat shall be signed by the person before whom the affidavit is sworn. The name of the person before whom the affidavit is sworn shall be printed below the signature of the jurat, and I actually use my stamp for that. An affidavit may be sworn before the solicitor who prepared the affidavit or before any person in the solicitor's office authorized to administer oaths. So that would also include paralegals. An affidavit is not invalid or otherwise improper by reason only that it was sworn before the action or proceeding was commenced. 369, the date when and the place where the affidavit is taken shall be set out in the jurat. 370, in an affidavit made by two or more deponents, the names of the persons making the affidavit shall be inserted in the jurat. But if the affidavit of all the deponents is taken at one time by the same officer, it is sufficient to state that in the jurat that it was sworn by both or all of the above named deponents. 371, where it appears to an officer administering an oath that the deponent is illiterate or blind, the officer shall certify in the jurat that the affidavit was read in the officer's presence to the deponent indicated that he or she understood it, and the deponent made his or her signature or mark in the officer's presence. So that's a little bit more detailed than what you presented, Matthew. This is much more authoritative because Matthew is drawing his statements from the guidebook. An affidavit of an illiterate or blind person shall not be used in evidence without the certificate referred to in Subrule 1, unless the court is otherwise satisfied that it was read to the deponent and that the deponent understood it. 372, where it appears to an officer taking an affidavit that the deponent does not understand the English language, a competent interpreter shall be sworn to faithfully interpret the contents of the affidavit, and the interpreter shall interpret the entire contents of the affidavit and the oath to the deponent. And the officer shall in the jurat certify that in his or her belief, the affidavit was faithfully interpreted to the deponent by the sworn interpreter and that the deponent understood it. 373, subject to Subrule 3, a deponent may state in an affidavit only what the deponent would be permitted to state in evidence as a witness in court. In an action or proceeding to which a corporation is a party, any affidavit required by these rules to be made by a corporate party may be made by an officer, servant, agent of the corporation who has knowledge of the facts to be deposed to, and the officer, servant, or agent shall state in the affidavit that he or she has the knowledge. 3, an affidavit may contain statements of the deponent's information and belief with respect to facts that are not contentious, if the source of the information and the fact of the belief are specified in the affidavit. 374, an affidavit may, with the leave of the court, be filed or used in evidence notwithstanding any irregularity in its form. So the affidavits do not have to be perfect. The court may order to be struck out any any affidavit, any matter that is scandalous, irrelevant, or otherwise oppressive. Where there is an interlineation, that's adding lines, alteration or erasure in the body of a jurat of an affidavit, the affidavit shall not be used without leave of the court unless the interlineation, alteration, or erasure is authenticated by the initials of the officer who took the affidavit. Oh, there's still more. Any document to be used in conjunction with an affidavit shall be an exhibit to the affidavit. We've already seen the stamp for that. An exhibit to an affidavit shall be identified by a certificate of the person before whom the affidavit is sworn. So I would argue that that stamp on the affidavit attachment or exhibit is actually the certificate. unless the court orders otherwise, where a properly marked exhibit is referenced or referred to in a filed affidavit and is not annexed to the affidavit, the exhibit need not be filed but shall be produced on the hearing of the application. A copy of an original affidavit received by facsimile machine may be filed in place of the original affidavit and used in evidence. A judge may give directions he or she considers necessary in respect of the use of a copy of an original affidavit received by a facsimile machine, including a direction requiring the filing of the original affidavit. So that's as far as the rules go for affidavits by electronic means. An affidavit that has been made and filed in an action or proceeding may be referred to and used at any stage of the proceedings in an application in an application in chambers. Cross-examination. Person who has made an affidavit filed by a party in an action or proceeding may be cross-examined on the affidavit by any party adverse in interest without an order of the court. The person to be cross-examined may be required to attend in the same manner as a party to be examined for discovery. So if you recall, there's generally a prohibition of notaries notarizing their own affidavits. And this is sort of where it's coming from. The rules that apply to examination for discovery of a party apply with such modifications as the circumstances may require to cross-examine on an affidavit. The party conducting a cross-examination on an affidavit shall cause a transcript of the cross-examination to be filed unless the filing is dispensed with by the court. The right to cross-examine shall be exercised with reasonable diligence, and the court may refuse an adjournment of any application or proceeding for the purpose of cross-examination where the party seeking the adjournment has failed to act with reasonable diligence. The court may impose such terms and give such directions for the conduct of cross-examination as will promote the just and effective determination of the proceedings. So this is just a reminder that Part 30 of the Supreme Court rules directly has a bearing on affidavits.
Okay, so some key points in the handbook that talk about how to swear, an affidavit. So the first one is, make sure the wording of the introduction of the affidavit talks about make oath and say, or the alternative that exists. The notary public should be identifying the person that is making the declaration or swearing the affidavit. So if you do not know who this person is, you should be asking to see their identification and making sure it's current valid government issued identification. You should be having the person read the affidavit out loud to you, so that way they are saying they understand what they're signing. They're signing whatever way, and know what's the contents of what's in the document. The notary public would be handing the person a Bible, an Old Testament, a New Testament, or a Quran, whichever applies to the religious beliefs. So alternatively, paragraph 21B of the evidence states that an oath can be administered to any person in a manner or form that, whatever ceremonies that's binding to their conscience. And Ian's going to talk about the chicken bones case.
So this is everybody's favorite case from law school, Brown and Louis. This is the chicken bones case, and it's from the CCC, the Canadian Criminal Cases, and I pulled this out from basically an internet article put out by the Courthouse Library of So that's I think that's in British Columbia. Anyway, it's talking about the so-called uncommon oaths. In this case, use of chicken bones was sufficient to meet the requirements for an oath. But remember, this is 1902, so they would have been really keen on using the Bible. And I think generally it was considered to, if they didn't allow the chicken bones, by our modern perspective, that would have been an absolute barrier to the access to justice. Also a bit of prejudice in favor of people who are Christian, Judeo-Christians. So this had to, it had to change, and we changed it in 1902. It is a British Columbia case.
So here is a sample of an affidavit. This one comes with the land titles. It's an affidavit of value for property. And as you can see, it identifies the person at the top. It talks about the affidavit. It has the words, make oath and say. It identifies the person, and then the contents are in there. And then at the bottom, we have the jurette area where we talk about the execution and the signature, which is identified over there.
So if you look at that slide, it's there are certain things missing, like the style of cause is missing. Not really a problem because maybe there is no style of cause yet, no court case. It is in the first person. There's no mention of occupation. Those are defects, but they're not fundamental defects because you can rely on that earlier provision in the rules of court to still put in a flawed affidavit as long as it's not fundamentally flawed. In this case, it's not signed, so that is a problem. If Matthew were the deponent, then he would sign on the right hand there. Doesn't say deponent, but we do know that on the left hand side, it is definitely the person authorized to take oaths. And you'll notice that it just says a person authorized to take oaths for use in the Northwest Territories. It doesn't say Notary Public, doesn't say Commissioner for Oaths. So it's a little bit incomplete. That is another flaw. Is it a fundamental flaw? Probably not.
And next up in the handbook, there's a little chapter about notarizing and certified true copies of documents. And there's a lot more detail provided in the handbook, but the summary is the steps a Notary Public should take is to accept the original, ensure it's the original and not a copy, and make sure it's not been previously notarized. The Notary Public should be preparing a copy and ensuring that the copy matches word for word and figure for figure for the original document. And then prepare a notarial certificate or use the provided wording of the certified true copy, which I put up on the screen earlier, and then sign and seal the copy and the certificate as appropriate. Here is an example of the notarial certificate, and it identifies who the Notary Public is, their authority, and their appointment. It identifies, in this case, there's several documents, and each one that would probably be referred to and identified in the attached documents. And then talk about how the notary has executed their duties of comparing the original document that they match in a true and faithful copy, and then identifying signed and sealed
If I were making a true copy of a original document, I would just put a little stamp in the upper corner, and if they wanted me to put on the seal, I would. The text of the stamp would be very similar to what is in the middle paragraph there. I've compared the copy against the original document. I certify that this photocopy is a true faithful copy of the original. So I have compared the copy against the original documents. Okay. Great.
Okay, so a summary of some common errors that we see at Legal Registries are as follows. So the first one is not properly verifying the identity of your client or the person who's swearing it, or they might have a slightly different name, or they might be going by an alias or something like that. The name is important to make sure it gets right. Number two is attempting to notarize the documents over the phone or not provide it for in a process that's required. Not affixing the seal for outside the use of Northwest Territories, and often we find other jurisdictions, notaries public go and are giving their clients documents which are then need to be used in Northwest Territories, and we have to say, sorry, it needs to be under the seal, and we don't accept them. Another one is we do find cases where people are acting as a notary public when they don't actually have that authority, and that's quite common actually for commissioners of oaths, and in which case we usually send them a letter to clarify what their authorities are. Next one is not maintaining your information or your specimens at legal registries. Not signing in the correct spots in the documents. Sometimes it's an issue of confusing where to sign between the client and the notary. And then the ways of conducting an amendment for any of those documents. Okay, so in summary, this is the topics we've covered over today's CPD. We talked about what are affidavits, statutory declarations, who are notaries public, the background, how the program is administered in this jurisdiction. Ian's talked about the Apostille Convention, and then we talked about the ethical considerations for the CPD purposes. And then I talked about some of the good information that you can find in the handbook, and you can find that on our website, and then did some examples. And if there are any questions, we'll be happy to field them now, or if they arise later, you can always contact Legal Registries at the phone number or email there on the screen.
Thanks, Ian. Thanks, Matthew. We'll just pause a moment to see if anybody wants to put in any questions through the chat function. And while we do that, I want to thank you for this presentation. I understand there were some audio problems. Hopefully, we were able to fix those. Ian and Matthew do have a PowerPoint, and it would have been sent out to you, hopefully. If you don't have it, you will be able to find it again on our YouTube channel, because we will post it when we post the the video of the presentation. We do have a question, and I don't know who this was directed to, so you two can sort out who's going to answer it. It's a little off topic, but do you have any suggestions as to how to get affidavits sworn for use in the Northwest Territories from another country? Any words of wisdom on that, either of you?
So that kind of goes back to the Apostille Convention that we are
not part of the Apostille Convention
Yeah.
at the moment, so there is
we would be able to address that through that process. But right now, if there was there was a bit of an audio thing. What we were talking about was that this is sort of a question that's the purpose of the Apostille Conventions, that exist in the other countries that have acceded to the convention, where a document that's executed in one country can be done in another. And it's one of the reasons why Canada is considering joining the convention. At this point in time, if there is someone in a foreign country that is going and executing an affidavit that meets their local jurisdiction's requirements, we do often accept those, and we would sometimes go and ask for authentication from that home jurisdiction through their various consulates or embassies here in Canada to ensure that whatever that document is does meet the equivalency and legal requirements in that country and has legal effect, and often it comes with a translation of what does this document say. It's on English or French.
there are also companies that do that as well. If you do an internet search for legal authentication companies, Canada, you will find quite a few of them. So the private sector is also involved in that.
Thanks for that. All right, I'm not seeing any other questions. So on behalf of the Law Society, I'd like to thank both of you, Ian and Matthew, for this presentation, and thanks to all of you for attending. And again, we will be posting this shortly on the YouTube channel. Thank you, everybody. Thank you very much, everybody. Have a great afternoon.
Thank you.
Thank you.